Welcome, friends, to this new lecture. The topic is on your screen: Basis of Law, Dharmashastra, Criminal Justice, Police, Jails, and Punishments. So, in these areas, we are going to discuss today. Agenda for today's discussion is on your screen. There are some queries basically that come to mind. What were the bases of law in ancient India? Then, what are Smritis, Grantha? Often we hear the name of Smritis and Dharmashastra. So, what do we mean by Dharmashastra? How social and judicial system was managed in ancient India? And are Dharmashastra basic books of judicial procedures or some other sources are also there? We will take up these things. Are there different forms of judicial systems with different sources, like other than Smriti Granth, other than Dharmashastras? What are other sources, like we have discussed about Kautilya's Arthashastra? So that is also one of the important sources. So in that perspective, we will explore more. Who were the authors to compose such vast list of procedures? Like today, even we find in the judicial system, CRPC, Criminal Procedure, Bharatiya Nyaya Sanhita, or earlier it was Indian Penal Code, and so many other procedures are there. So, what Indian knowledge tradition says about it, and what are other sources upon which our law system is based, and it was based in ancient India, and what happened in later periods. So, in this particular lecture, we are confined just to explore the judicial system in ancient India. We are not touching here in this lecture the medieval India or the colonial part. So, let's come to the discussion. What is judicial system? A judicial system is the network of courts and legal professionals that interprets and applies laws to resolve disputes and administer justice within a country. It is basically a fundamental branch of government that handles both civil and criminal cases. Even today, if we see that in our parliamentary system, we have the executive, we have the legislatures, and we have the judiciary. So that is the integral part of the government. In ancient India, the judicial system was a hierarchical structure of courts designed to administer justice based on the principles of dharma, that is righteousness, and social customs. So, always there has been an adage before the judicial system. Um, you see often written on the courts, basically some adages, Satyamev Jayate, and so many other adages or statements from the scriptures or from the sources that just give a guideline or a Baconian a way to do the justice or to do the activities in judicial system. So it has been a tradition that dharma, the righteousness based on the responsibilities of judiciary, and social customs are also one of the fundamental sources of designing the principles and procedures of judicial system. So it was a multi-tiered system with at one level local councils, village level, regional level, district level, or at the central level, that is Supreme Court. Even today we find this from district to High Court to the Supreme Court. This hierarchy is still going on. And in ancient India, it was headed by king. As we see today in the Supreme Court, the Chief Justice of India is the supreme authority in judicial system. In ancient India, the supreme authority was king, where higher courts had the authority to review decisions from lower ones. Judicial system in ancient India basically is concerned with certain aspects. One of them is hierarchy of courts. The system had a clear hierarchy from local arbitration to the king's court. Then family courts were there. Then village courts were there. That is known as village panchayats. They were authorized to take certain decisions in the light of the social customs, in the light of the evidences, or in the light of consensus, with the help of a group of people, those who were the members of panchayat, and town district courts. And we have already discussed about this panchayati raj vyavastha in one of the lectures when we were discussing about the South Indian in Chola administration. We find some scriptures where we find the sources of panchayati. Village panchayats were there. And then you see that town, district courts, these courts managed by government officers dealt with more common civil and criminal matters. Then Chief Justice was basically the King's Court at the top. And the King's role was very important. He was ultimate judicial authority and was responsible for upholding dharma and ensuring justice for all his subjects. Then there were certain special courts. The Arthashastra of Kautilya mentions specialized courts like the Kantakashodhana court, which handled offenses against the state and misconduct by officials. That is, state versus some either individuals or state versus state and so on, or center versus states. So some specialized courts were there. So we will also come to that. Judicial system in ancient India again was deeply rooted in Dharmashastra traditions. These were the sources or the genesis. The later Smritis like Narada Smriti, Brahaspati Smriti, and Katyayana Smriti mark the most refined and systematic development of ancient Indian jurisprudence. These texts represent a transition from moral dharmic justice or religious justice, that is, religion, I have already told you, that is not the right word for the dharma. Dharma was the basis of justice to a formal, procedural, and royal judicial system. That was Vyavhar in applied aspects. Now, come to the point that what is Smriti literature? Because this is the fundamental source of judicial system in ancient India. And whether Smriti literature are the basis of Dharma Shastras, or Smritis or Dharma Shastras are the part of Smriti literature, and what happens. So we find that in Sanskrit the word Smriti literally means that which is remembered. Hindu sacred texts are divided into two parts, or you see that Vedic sacred text. Shruti means what is heard, that is the Vedas. So we find the entire corpus of Vedic literature is divided into certain categories. One of them is the Samhita, then Brahman Granths, then Aranyak Granth, and then Upanishads. So Shruti basically is known, the term it is used for the Vedas, because Vedas were compiled, not composed by human being. They were compiled by the rishis and manishis, and they heard those divine verses when they were in the deep meditation. So they are also called the Aparushe, not composed by any human being. On the other hand, Smritis are basically known as traditions that were remembered or written by human authors or compiled by the people. Smriti functions as a secondary book of literature, secondary body of literature. It depends on the authority of Shruti, and its role is to interpret, apply, adapt, codify, and elaborate Vedic based traditions. So Smritis Granth are not apart from Vedic, but their source is different. Smritis are the interpretation of the Vedic sources, Vedic mantras, in the light of the context of society. Smriti texts were considered less authoritative than Shruti in divine matters, because you may take the solutions for the social problems, but for the divine problems of the divine matters, Vedas are the ultimate authorities, the testimonies. In practice, they had wider influence in the fields of law, ritual, social ethics, and everyday conduct. Then Smriti literature expanded greatly beyond just law books. Apart from the law and procedural codes or the judicial system, Smriti books also provide the guideline in the social matters, in social affairs, and social etiquettes and manners and rules and regulations and code of conduct, code of ethics, and so on. So in moral, in ethics, in all these areas, they also provide some guidelines. The term came to cover a wide range of post-Vedic Sanskrit literature, that is Vedangas, Purans, Itihas, Kavyas. They are all the part of the Smriti literature, because these were composed with the basic source of Vedas. Now we can have a glimpse on what Shruti and what Smriti consist of. So Shruti, the meaning of Shruti is the what is heard, that is Veda, the collection of all spiritual knowledge. Basically, there are four Vedas. We have already studied in one of the first lectures, early lectures: Rig Ved, Sam Ved, and Yajur Ved, and Atharva Veda. And you see that Rig Veda is basically known as the Samhita, collection of hymns, collection of mantras. And then another is the Brahman Granth, the ritual explanations, the Karma Kanda. And then Aranyaka, these are the forest treatises. They were composed for the people who used to live in Vanprasth ashram, Vanprasthi, and composed on the basis of their experiences about life and its phenomena. And then Upanishads, highly philosophical discourses, philosophical treatises. They were composed out of the pedagogical contemplation or pedagogical interpretations in the form of dialogues, in the form of anecdotes, in the form of Shastrarth, and so on. These were the different methods. So these are the four broad categories of Vedic literature. On the other hand, the Smriti Granth consist of the supplementary books in order to understand those Shruti literature. Like Upavedas, they considered basically Ayurveda, Dhanurveda, Shilpveda, and Gandharva Veda. They are the subsidiary Vedic text. Then Vedangas, they were written in order to understand the lexical aspects, the etymological aspects, or the related to astronomical aspects of the Vedic content. So Vedangas are basically are known as the limbs of the Vedas, which are required to understand the basic interpretation of the mantras. There are the six limbs of the Vedas: Shiksha, Kalpa, Vyakaran, Nirukta, Chanda, and Jyotish. We all have studied about them. And then Shad Darshana, six schools of Indian philosophy. However, in ancient India, these schools were not clearly defined. Only in the 16th century, when Madhvacharya composed a book, Sarv Darshan Sangrah, we find the mentioning of different schools of philosophy. So, on that basis, we can say that on the basis of the categorization of the thought and interpretation of Vedic ideas, there emerged the six schools of Indian philosophy, basically having the roots in Vedic literature: Sankhya, Yoga, Nyaya, Vaisheshika, Mimamsa, and Vedanta. And in 6th century BC onwards, some other schools of philosophy emerged, like Jainism and Buddhism and Charvak and many other skeptic schools also. So they emerged. But these six schools are basically associated with the Vedic roots. So they are also called the Orthodox schools, or sometimes it is the Astic schools. Uh, then Puran. There are 18 Puran. They are the books of traditions and legends and mythological history, mythological chronological records based on the divine interpretations or divine descriptions or the divine narrations. So Puranas are also basically the sources of history, but not in the scientific sense. They are the traditions, they are the collection of legends. And Itihas, basically historical events. And in Itihas, normally the Ramayana and Mahabharat epics normally are the part of the Itihasa. And then Dharmashastras, they are the socio-religious works. They are the outcome of the Smriti literature. On the when we codify the rules and regulations for judicial decisions or for social decisions in order to solve the social problems, they become the Dharmashastras. So they are the books of rules, they are the books of codification, and so on. So this is the entire description of the Smriti literature. So coming to the next level of discussion, evolution of Dharmashastra, why they were needed, why books of codifications were needed, or code of conduct was needed. Many Vedic shakhas have become extinct. Therefore, all Dharma Sutras content cannot be directly traced to existing Vedas, because during the Vedic period, certain sutras like Grah Sutra, Shot Sutra, these were composed in order to keep in mind what code has been decided, what code has been created for the smoothful functioning of the society. But different these shakhas were eliminating with the expansion of society, with the expansion and introduction of new ideas, and the business and the social structure was expanding. So in that way, it could be not possible to just revive or sustain those shakhas. So then what happened in the later period, as the society grew over time, such an organization cannot sustain without a minimum number of laws, customs, and regulations. When people emerged in number, therefore certain problems also emerge along with their necessities and need. So new laws and new customs and new regulations were also the need of the time. Thus new customs evolved to find solutions to newer problems, bringing about the essential change in dharmas along with the population by the migration, new structure of socio-economic or socio-cultural fabric in the society. Some new problems also emerged, so new solutions were also required. Obviously, they led to new Dharma Sutra formulations. So, Dharma Sutra thus consists of systematized inherited custom, addressed emerging social, political, and theological problems, reflected the spirit and needs of their time. Then earliest Smriti text on law, Dharma Sutras, would consist. Dharma Sutras has set three sources of Dharma: Shruti, four Vedas; Smriti, traditional text; and Achar Sanghita, that is code of cultured people. For examples, Gautam Dharma Sutra, Veda is the source, tradition follows it. Then Badhayan Dharma Sutra, Dharma explained according to Veda, tradition is secondary. And Vashishta Dharma Sutra, when Veda and Smriti are silent, the practice of good people is authoritative. So on your screen, you can have a glimpse that in this given table, certain authorship and dating are given. This is approximate time is given here. Manusmriti is the oldest one. It is also called as the Manava Dharmashastra, associated to the Manu, who is the compiler and composer of it. So Manu has a different interpretation. Sometimes he is not a person and he is the part of this entire Naitik Vyavastha of the universe. Or on the other hand, many people describe that he is the composer of this entire system upon which this universe is functioning. So it's not there's no scope in this lecture about this detail. But the Manu Smriti is one of the earliest sources of this judicial system, and later Smritis also take the references from Manu Smriti. It is a book concerned with the second century before Christ and second century AD, Christian era. So in between these 400 years, this was composed somewhere. Then Yagvalkya Smriti, 3rd to 5th century. All other Smritis were composed in the Christian era. Only Manu Smriti was composed before Christian era. So Narada Smriti, Brahaspati Smriti, Katyayana, Vishnu Smriti, and Parashara Smritis. These are the basic books of the sources of judicial system, and what code of conduct was based, that came to be known as the Dharma Sutras. Vashish Dharma Sutras, Apastambh Dharma Sutra, and Gautama Dharma Sutra, and Bodhayan Dharma Sutra. And the last of all was the Deval Smriti. Deval Smriti is concerned with the 5th and 8th century CE, and it is the Smriti book which mentions the Arab invasion of Muhammad bin Qasim on Sindh. So this is the only source where we find the detailed description of this Arab invasion during the around 712, because this time period is covering this 5th century to 8th century. So the Smritis are sometimes also the sources of some historical events. Then we can have a comparison between among Shruti, Smriti, and Dharmashastra. We see on the part of meaning, Shruti means that which is heard, divine revelation. Smriti means that which is remembered, tradition remembered by sages. And Shastras, treatises on Dharma, law books based on Smriti. On the part of nature, eternal, impersonal, revealed truth. And Smriti means human authored but rooted in Vedic principles. Shastras, systematic legal and ethical codes derived from Smritis. Then, as far as authorities are concerned, Shrutis are the highest authority in Hindu tradition, but Smritis are the secondary authority, valid when aligned with Shruti. As far as Dharma Shastras are concerned, they are the subcategory of Smriti, authoritative for law and social conduct. Regarding content, Shruti consists of hymns, philosophy, rituals, metaphysics, and for Smriti, social customs, ethics, duties, rituals, daily conduct. And in Dharma Shastra, there are civil criminal laws, duties of king, court procedures, penances, punishment procedure, and so on. Then regarding flexibility, Shrutis are fixed, unchangeable. Smritis are flexible, changes with time, Yug Dharma. According to the context, according to the change in society, Smritis procedures may be changed. And regarding Dharma Shastra, revised periodically by sages to suit new social needs. So they are more flexible as compared to Smriti. But Shrutis are the fixed. That's why they are because they are called as the Aparushya. And regarding the purpose of Shruti books are spiritual and philosophical foundation. Smriti books have a purpose for practical application of dharma in life, the duties, obligations, and Dharma Shastras are concerned with regulation of society, governance, and justice. And for example, Shruti, Rig Veda, and Upanishads, example of Smritis are Manu Smriti, Yagvalkya Smriti, and Dharma Shastras, Narada Smriti, Parashara Smriti, and Manu Smriti. They are also the Dharma Shastras. So why there's a need of Smriti or Dharma Shastra in ancient Indian society? So Smritis and Dharma Shastras played a vital role in shaping the moral, social, and legal framework of ancient Indian civilization. Their creation was necessary due to the following reasons: to apply Vedic teachings to daily life, we have already discussed about it, to organize a growing and complex society. So you may pause the screen or you may go through the points here. Then another need was to provide a code of conduct for Varna Ashram Vyavastha. Varna and Ashrama, there were the four Varna Ashram Vyavasthas, and Ashram Vyavasthas were there. So in that perspective, what a person has to do, that is mentioned here: to establish legal order and governance, that is ultimate object; to maintain moral discipline and social harmony; then to adapt dharma to changing times. And now we come to some specific smritis and sources of judicial law. Like Narad Smriti is one of the fundamental source of judicial law. It focused exclusively on legal dicta, not religious atonement. Considered royal edict, that is Raj Shasana, superior even to Smriti text. It introduced detailed legal procedures emphasizing documentary evidence over oral testimony, and legal titles 18 Vyavhara padas such as the debt, theft, inheritance, assault, and gambling. So these are the subject matter, and it is more important because it mentions the documentary evidence over the oral testimony. That is the fundamental change as compared to the earlier judicial system. Reflected a commercially advanced society during Guptan period and recognized state regulated gambling as lawful. Social liberalism allowed remarriages of widow, niyoga system, and examination of bridegroom's potency. In that perspective, you see that a certain procedures which were not endorsed in earlier society, that these were endorsed in the Narada Smriti. So it is that's why Smritis are a little flexible. Then Braspati Smriti is another Smriti that emphasized judicial procedure and evidence similar to modern law. Distinguished civil and criminal suits, a significant advancement. It gave more importance to documentary and witness evidence, condemned arbitrary justice, and upheld procedural fairness. It was composed between second to fourth century, and then recognized women, widows, and daughters as legal heirs. So this is the the uh, legal status of the women in the part of the heirs, or the just associated to the property in the share in the property of the parents. Braspati Smriti provides this procedure. Katyayana Smriti represents the highest refinement of Indian legal thought, elaborated legal distinctions, inheritance, property, division, contracts, etc. It classified Istridhan, women's property. This is a term which we find from even that's very popular today, and gave women absolute rights over it. Differentiated between Jayapatra, that is ex parte decree, and past Katra, that is judgment after trial. These are the terms which are legal terms used by Katyayana Smriti. It upheld limits on royal ownership. The king was not the absolute owner of land. Then again, you see judicial concepts and processes, meaning and nature of vyavhar, lawsuits, a legal dispute between plaintiff and defendant to establish truth, purpose to remove doubt and ensure justice. Two bases: disputes arising from wealth, that is dhan, mool, and injury, that is hinsa mool, akin to civil and criminal law. So there are certain other concepts and processes like fourfold foundations of the justice: dharma, that is moral law; vyavhar, judicial proof; charitra, custom and usage; and Raj Shasana, the royal decree. So this terminology is also important in the judicial system. Then certain judicial institutions were there: the king and his court. The king was chief justice, and his the court was called the Dharmashastra, seat of justice. The judge, uh, Pradvik, Pradivaka, the term which is used for the judge, derived from to inquire and to speak truth. And his duty was to extract justice like a surgeon removes a dart through investigation. It required to be learned, impartial, and of high moral integrity. So even the qualities or the requirements of the judge and the legal officials were also described by the Smritis. The assessors, sabhyas, the members of the judicial system, assisted the judge. Number varied from 3 to 7. Qualifications: knowledgeable, honest, non-greedy, impartial. So we see that in ancient India, even the qualifications were defined for the judicial system, even for the village panchayat. members. You see in various sources we find such type of procedures. Types of courts were there: Sthavar or Pratisthita, that is permanent local court; Aparathisthita, that is mobile court accompanying the king wherever king goes. Because he himself is the court, so he just opens his court and he used to listen the issues and problems of the people, his subject. Mudrita, court with royal seal under appointed judges, some representatives on behalf of king. And then Shasita, that is court presided over the king himself. Then subordinate tribunals, proto-panchayats, kula, family or clan-based council, Shreni, guilds of artisans or traders, they also sometimes act as the court for commercial issues. And then Puga, mixed caste community of a town or village. Then Gana, that is learned Brahmins or the religious collectives. And then each higher court had appellate authority over the lower one. Only the king's court could impose fines and corporeal punishment. Then we come to police, jail, and punishment. Then policing and enforcement, royal officers enforce the king's justice and law. Guilds and village heads acted as local law enforcers. Police also served to maintain order, taxation, and evidence collection. Jail and detention. Detention or restraint was known as ashedha, that is applied when the defendant might abscond. Property of the accused could be temporarily seized and held by a neutral party, early form of receiver. Then punishment system was that dand was not vengeance but moral correction. It was not treated as a revenge. Types of punishments were monetary fines, public rebuke, corporal punishment, physical punishment, banishment or imprisonment. Sabhyas or the judges giving wrong or biased verdicts were also fined or expelled. Then repeated offenders could be deprived of property or exiled. So what was legal procedures? Plaint and defense. The plaintiff or Vadin presents Purva Paksha. The defendant Prativadin presents the Uttara. The plaint had to be clear, brief, provable, and specific. Then again, defense could include the denial, admission, special plea, former judgments, re-adjudication, etc. Or evidence pramans of two kinds. There were two kinds of evidences: human documents, witness processions, or the divine ordeals. Human proofs were preferred, ordeals used only when human evidence failed. Documentary evidence held highest value, followed by witness and processions. Then, regarding the witness, classified as appointed krata and unappointed akrata. Validity of testimony depended on memory and moral integrity, and false witnesses were also severely punished. So, circumstantial evidence were also given importance, accepted in cases like found with weapons, that is murder; near fire with torch, that is arson; holding another's wife, that is adultery. So, in those cases, circumstantial evidences were of high importance. Such self-evident situations eliminated the need for witness. So, we find the roots of modern judicial system are also there in ancient judicial system based on these very specific sources. So other legal procedures were oath and ordeals, judgments and records. And as far as Kautilya's Arthashastra is concerned, it also provides certain procedures. However, many of the procedures were also based on the Smritis. Nature of judicial administration, Arthashastra defines king as the supreme judge. He also gives his ideas. Organization of courts like Dharmashastra court, civil court dealing with property, family law, inheritance and contracts. Then Kantakshodhana court, court for criminal matters, economic offences, trade violations, fraud and public order. Then Rajdharma court, the king's court for appeals and important cases. Then again, you see judges and judicial officers. Arthashastra gives a detailed description about it, basically based on the earlier what we have discussed as associated with Smritis and Dharmashastras. Laws of evidence, documentary evidence, that is called Lekha; witness testimony, that is Sakshin; circumstantial inference evidence, that is Yukti; and oaths and ordeals, that is Divya. So certain terms were introduced by Kautilya's Arthashastra that they are still evident today. Types of punishments were dand, fine, imprisonment, confiscation of property, banishment, and so on. Harsh punishments for treason, theft, economic fraud, etc. Protection of weaker section is one of the important procedure at that time. Special safeguards for women, children, artisans, traders. the poor, slaves, and servants. Then severe penalties for exploiting dependent groups. So Kautilya Arthashastra is more contextual with the society, and whatever was the need of society, that was suggested by Arthashastra regarding economic crimes, tax evasion, black marketing, adulteration, false weights and measures, and misappropriation of state resources. Then these are the categorized in economic crimes. Then anti-corruption provisions was also suggested by Kautilya's Arthashastra, one of the earliest texts to discuss corruption in detail. That's the very important aspect of Arthashastra. Strict surveillance, audits, spies, and several punishments. It is impossible not to taste honey when it is on the tip of the tongue, used to argue the need for vigilance. So certain courts are with reference to the need of this particular procedure. And if we just have a glimpse of the Mauryan period, we find all those systems which was either because Mauryan period judicial system was largely and heavily based on the Kautilya's Arthashastra and earlier Dharma Sutras regarding the role of king, types of courts, judicial officers, legal sources, and certain features are there, punishments, policing system. So you may also pause the screen and you may go through it. All the points are almost mentioned by the Arthashastras by Kautilya. And judicial system during Guptan period, we see 4th and 6th century. Again, the Dharmashastra traditions, dharma, custom, and caste duties. Sources of law, basically Smritis, Manu, Yagval, commentaries like Megha Tithi, and local customs and caste rules, royal decrees outside. And judicial officers were kings, sabhas, parishas. So all those officers were there. But this Guptan period was a little more advanced system because it also contextualized and whatever modification was required, they did it. Then again, you see judicial hierarchy was same from village to district to state or the central level. The highest authority was king, and punishments were features of Guptan judicial system. These all resemble the Mauryan period and little changes because some commentaries of Megha Tithi and Jimut Vahan, Dai Bhag, etc. These commentaries were also their interpretations of the laws were there. So the new context were emerging, and in that period, that's why these modifications were done. So to conclude, we can say the judicial system of ancient India was deeply rooted in dharma, where law, morality, and social duty formed an integrated framework of justice. Dharmashastras provided a comprehensive and systematic codification of civil, criminal, family, and ethical laws, guiding both rulers and citizens. Justice was considered a sacred responsibility. That's why it's called the dharma of the king. And systems from Kautilya to the Guptan emphasized fair judgment, prevention of corruption, and protection of social order. And overall, we can say that ancient India's legal tradition evolved continuously, adapting dynamic principles to changing social needs and laid the foundation of later Indian jurisprudence. So, thank you very much for joining this very important discussion. I'm leaving you with the beautiful word of Martin Luther King. The laws are not to change the heart, but to restrain the heartless. Thank you very much. God bless you.